I'll be reading these to you. There'll also be copies in the jury room for your usage, so this will not be the only time you'll be able to look at them. All right. In the Iowa District Court for Chickasaw County, the State of Iowa versus Cheyanne Harris, FECR 011491. Instructions to the jury. The court submits the following instructions to the jury. Instruction number 1, the trial information charges the defendant, Cheyanne Harris, with 1 count of murder in the first degree and 1 count of child endangerment causing death. Count 1 includes the lesser included offenses of murder in the second degree and involuntary manslaughter. Count 2 includes the lesser included offenses of child endangerment causing serious injury, child endangerment causing bodily injury, and child endangerment. 2. Cheyanne Harris has entered a plea of not guilty. The plea of not guilty is a complete denial of the charges and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 3. The trial information is a document that formally charges the defendant with a crime and is merely the method by which the defendant is brought into court for trial. It is not evidence. Number 4. Cheyanne Harris is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. 5. You shall base your verdict only upon the evidence in these instructions. Evidence is testimony in person or by deposition. Exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. Stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, court filings, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers. Excuse me. Objections and rulings on objections, any testimony I told you to disregard, and anything you saw or heard about this case outside the courtroom. Instruction number 6. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. As you consider the evidence, do not be influenced by any personal sympathy, bias, prejudices, or emotions. Because you are making very important decisions in this case, you are to evaluate the evidence carefully and avoid decisions based on generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your reason and common sense, and these instructions. As jurors, your sole duty is to find the truth and do justice. Reach your verdict without discrimination. In reaching your verdict, you must not consider the defendant's race, color, religious beliefs, national origin, or sex. You are not to return a verdict for or against the defendant unless you would return the same verdict without regard to her race, color, religious belief, national origin, or sex. 7. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, whether the testimony is reasonable and consistent with other evidence you believe, whether a witness has made inconsistent statements, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts, the witness's interest in the trial, their motive, candor, bias, and prejudice. 8. You must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. You must consider all of the instructions together. No one instruction includes all of the applicable law. 9. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. 10. The burden is on the state to prove Cheyanne Harris guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or from the lack or failure of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond a reasonable doubt does not mean proof beyond all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, you are the duty of if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. 12. Prior sworn testimony from Zachary Cohen was read into the record. This testimony was taken under oath before the trial and preserved in writing. Consider that testimony as if it had been given live in court. 13. In this case, the defendant did not testify. The defendant is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of the defendant. 14. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act, and he did it voluntarily, not by mistake or accident. You may, but are not required to conclude a person intends the natural results of his acts. 15. Serious injury is a condition which cripples, incapacitates, weakens, or destroys a person's normal mental functions, or a bodily injury which creates a substantial risk of death. 16. Bodily injury means physical pain, illness, or any impairment of a physical condition. 17. The marshalling instruction. Under count 1, the state must prove all of the following elements of murder in the first degree. 1. During the time frame of August 4th, 2017, through and including August 30th, 2017, the defendant killed S.K. 2. S.K. was under the age of 14. 3. The defendant did so with malice aforethought. 4. The defendant was committing the offense of child endangerment as defined in instruction number 21. 5. S.K.'s death occurred under circumstances showing an extreme indifference to human life. If the state has proven all of the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will consider the charge of murder in the second degree explained in instruction number 23. 18. As to element number 3 of instruction number 17, malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another, in disregard of the rights of another, out of actual hatred or with an evil or unlawful purpose. Malice may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do an injury. Malice may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice aforethought is a fixed purpose or a design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. 19. Malice may, but need not be, inferred from the commission of child endangerment resulting in death. 20. Concerning instruction number 1 of instruction number 17 and instruction number 22, the defendant killed S.K. if her actions caused or directly contributed to S.K.'s death. 21. Concerning element number 4 of instruction number 17, the defendant committed child endangerment if she, as the parent of SK, intentionally committed an act or a series of acts using torture or cruelty that resulted in bodily injury to SK. 22. State must prove all of the following elements of murder in the second degree between August 4, 2017 and August 30, 2017. Defendant killed SK. 2. The defendant acted with malice aforethought. If the defendant has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of involuntary manslaughter explained in instruction number 23. No matter how many times I proofread these, when I read them out loud, I always find typos, so I'm seeing them too, so I apologize, all right? Instruction number 23, the state must prove all of the following elements of involuntary manslaughter. 1. Between the 4th day of August 2017 and the 30th day of August 2017, defendant recklessly committed a series of acts using torture or cruelty that resulted in bodily injury to SK. The defendant did the act in a manner likely to cause death or serious injury to the child. By doing the act, the defendant unintentionally caused the death of SK. The state has proved all of the elements. The defendant is guilty of involuntary manslaughter. The state has failed to prove any one of the elements. The defendant is not guilty of involuntary manslaughter, and you will consider the charge of child endangerment causing death in count 2, explained in instruction number 24. 24. Under count 2, the state must prove the following elements of child endangerment causing death. Between the dates of August 4, 2017 and August 30, 2017, the defendant was the mother of SK. 2. SK was under the age of 14 years. 3. The defendant willfully deprived SK of the necessary food, water, health care, or supervision appropriate for a child of SK's age. 4. The defendant was reasonably able to provide food, water, health care, or supervision to SK. 5. As a result, SK suffered substantial physical harm. 6. SK died as a result of the substantial physical harm. If the state has proved all of the elements, the defendant is guilty of child endangerment causing the death of a child. If the state has failed to prove any one of the elements, the defendant is not guilty of child endangerment causing the death of a child, and you will consider the charge of child endangerment causing serious injury explained in instruction number 25. 25. The state must prove all of the following elements of child endangerment causing serious injury. Between August 4, 2017 and August 30, 2017, the defendant was the mother of SK. SK was under the age of 14 years. 3. The defendant willfully deprived SK of the necessary food, water, health care, or supervision appropriate for a child of SK's age. 4. The defendant's act resulted in serious injury to SK. The state has proved all of the elements. The defendant is guilty of child endangerment causing serious injury. The state has failed to prove any one of the elements. The defendant is not guilty of child endangerment causing serious injury, and you will then consider the crime of child endangerment causing bodily injury as explained in instruction 26. 26. The state must prove all of the following elements of child endangerment causing bodily injury. Between August 4, 2017 and August 30, 2017, the defendant was the mother of SK. 2. SK was under the age of 14 years. 3. The defendant willfully deprived SK of the necessary food, water, health care, or supervision appropriate for a child of SK's age. 4. The defendant's act resulted in bodily injury to SK. If the state has proved all of the elements, the defendant is guilty of child endangerment causing bodily injury. If the state has failed to prove any one of the elements, the defendant is not guilty of child endangerment causing bodily injury, and you will consider the crime of child endangerment as explained in instruction 27. 27. The state must prove all of the following elements of child endangerment. 1. Between August 4, 2017 and August 30, 2017, the defendant was the mother of SK. 2. SK was under the age of 14 years. 3. The defendant willfully deprived SK of the necessary food, water, health care, or supervision appropriate for a child of SK's age. If the defendant, if the state has proved all of the elements, the defendant is guilty of child endangerment, If the state has failed to prove any one of the elements, the defendant is not guilty of child endangerment. 28. As used in paragraph 1 of instruction number 23, a person is reckless or acts recklessly when the person willfully disregards the safety of persons. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee that harm will more likely than not result from the act. The recklessness is willful, it is not intentional in the sense that harm is intended to result. 29. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. 30. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. 31. You've heard evidence claiming some witnesses made statements before the trial while under oath which were inconsistent with what they said in this trial. If you find these statements were made and were inconsistent, then you may consider them as part of the evidence, just as if they had been made at this trial. You may also use these statements to help you decide if you believe the witnesses. You may disregard all or any part of the testimony if you find the statements were made and were not consistent with the testimony given at trial, but you are not required to do so. Do not disregard the trial testimony if other evidence you believe supports it, or you believe it for any other reason. 32. Evidence has been offered to show that the defendant made statements at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence. Statements and questions by law enforcement officers during interviews with the defendant are not evidence to be considered for their truth. The defendant's answers and responses to those questions and statements are evidence. 33. The defendant has been charged with 2 counts, including lesser offenses of each count. This is just a method for bringing each of the charges to trial. If you find the defendant guilty or not guilty on one of the counts, you are not to conclude the defendant is guilty or not guilty on the other. You must determine whether the defendant is guilty or not guilty separately on each count. 34. Where 2 or more alternative theories are presented, or where 2 or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. 35. The defendant's purpose in offering the testimony of Dr. O'Hara was not in furtherance of a claim she was insane or incapable of forming a specific intent to commit a particular offense in August of 2017. You may consider the testimony in determining whether she was aware she was doing an act and whether she did it voluntarily, not by mistake or accident. 37. During the trial, you've been allowed to take notes. You may take these notes with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. When you begin your deliberations, you should select a foreman or forewoman. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement, if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong. but do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are the judges of the facts. Your sole duty is to find the truth and do justice. 39. Occasionally, after a jury retires to the jury room, the members have questions. Usually, questions about instructions can be answered by carefully rereading them. If, however, any of you feels it necessary to ask a question, you must do so in writing and deliver the question to the court attendant. I cannot communicate with you without first discussing your question and potential answer with the parties and the lawyers. This process naturally takes considerable time to assemble the parties excuse me, and lawyers before I can reply. Keep the question in response and return it to the court with the verdict. You will soon be discussing the case among yourselves. However, you are still prohibited from communicating about this case with anyone outside the jury room before reaching your verdict. This includes cell phones and electronic media such as text messages, Facebook, Twitter, email, etc. Do not do any research or make any investigation about this case on your own. Do not use internet maps or Google Earth or any other program or device to search for or to view any place discussed in the testimony. Also, do not research any information about this case, the law, or the people involved, including the parties, the witnesses, the lawyers, or the judge. This includes using the internet to research events or people referenced in the trial. This case was tried on evidence presented in the courtroom. If you conduct independent research, you will be relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that has been introduced here in court. If you do research or investigation or experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth and by cross-examination. All of the parties are entitled to a fair trial, rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based on information not presented in court, you will have denied the parties a fair trial in accordance with the rules of this state, and you will have done an injustice. It is very important that you abide by these rules. 41. I'm submitting to you 2 verdict forms, one for each count. Each form contains the original charge and lesser included offenses. Shall only render 1 verdict on each count. When you have reached a unanimous verdict and complete the verdict forms, inform the court attendant. Verdict form number 1, State of Iowa versus Cheyanne Harris. We, the jury, find the defendant, check 1 box. Guilty of murder in the first degree. Guilty of murder in the second degree. Guilty of involuntary manslaughter. Not guilty. Signature line for the foreperson. Verdict form count number 2. We, the jury, find the defendant. Check 1 box. Guilty of child endangerment causing the death of a child. Guilty of child endangerment causing serious injury to a child. Guilty of child endangerment causing bodily injury to a child. Guilty of child endangerment. Not guilty. Signature line for the foreperson. Mayor Lee, would you go get Barb, please? It's now time for counsel for each side to present their closing arguments or summations of the evidence. Counsel for the state will have the opening summation. Counsel for the defendant will then have an opportunity for reply, and since he will only address you once, will present the defendant's summation. Counsel for the state will then have a closing reply to the argument of the defendant. The lawyers will be commenting upon the evidence which has been presented during the trial. They will not intentionally mislead you, but if their recollection of the testimony is not the same as yours, you must follow your own recollection and rely on that. Summations and closing arguments of counsel are not evidence, and if the attorney's references to law are inconsistent with the court's written instructions, you must follow the written instructions. Summations and arguments are to help you understand the contentions of each side. Please give them your utmost attention. Ms. Timmons.